family planning and how that can blended family situations can impact estate planning and potentially long-term care planning as well. So just a couple quick things before I go into a lot of information. I'm attorney Justin Randall with Hooper Law Office, one of the attorneys at our office. You may be familiar with me if you've seen me on these a lot, or myself and Abigail, one of our other attorneys. But you will also receive a couple of things from us as part of this. So we're going to send things to the email you use to sign up. One is a handout associated with the topic we're talking about today. And then we're also going to be sending out a feedback form for you to fill out if you have any feedback or topics you'd like to hear us talk about in the future. But it also does give you a place to fill out if you'd like to have us reach out to you so that we can set aside time for an initial consultation. If we talk about anything today that raises concerns for you or applies to your situation, you want to come talk to one of us. We can't reach out to you unless you mark that you would like us to. So that gives you a place to do that. Our initial consultations are complimentary. We don't charge for those initial meetings. We schedule them for about 2 hours to give us plenty of time to go through the situation, especially in the blended family context. Things can be a little more complicated with assets and how you want things to be divided up. But we also ask you to, speaking of assets, bring in quite a bit of information on accounts that you might have on your family so that we can get a really good sense of what your situation is. And that allows us to give you the best recommendation, usually by the end of that 2 hour period of time. If we need to meet for longer or additional meetings, we certainly can as well. And that handout that we're giving you is our document finder, which is really a helpful tool where if you have estate planning documents, you have financial assets, it gives you a place to say, hey, here's where our power of attorney is being kept, so that you can put it on the fridge or whatever, and the kids can find it and know where to look for your healthcare power of attorney if you have a copy they need, or look for the financial power of attorney. And again, this is a interactive webinar, so you can actually submit questions to me through the Q&A function, and I will see those pop up and answer them as they come up. So the more questions you have, the better, and that's on Zoom. So Zoom has the Q&A function. So yeah, to get started, talking about blended family planning, there's a lot of really particular concerns that you have to focus on when you have a blended family, especially when maybe each spouse has a different idea of where they ultimately want things to go when they pass away. The biggest risk and probably the most common issue we run into with blended families is when they don't have any planning at all. A lot of people don't understand what happens if you have no planning, like where things just automatically go. And if you have an idea of where you want things to go, it's always better to put that planning in place yourself than to just hope for the best and rely on these default statutes. So if you don't have any planning in place, where your assets are going to go upon the first death really depends on a couple things. One, it depends on how those assets are owned. So if things are owned as joint ownership or joint tenancy on property, well, the surviving owner may end up being the owner of all those accounts. And if you intended for part of that value to go to your kids on your first death, as opposed to all over to the surviving spouse, if there's that joint ownership on things, that could potentially be an issue. If that was your intended result, then great. But the problem with that is you need to be very aware of how these ownership types of accounts and ownership types on real estate can impact where these assets ultimately go. You also have to be aware that when you have beneficiary designation, so if it's an individually owned account, but your intent was, well, I'd love for my spouse to get part of that, or I'd want my kids to get part of it, but your beneficiary designations don't match up with that intent, those beneficiary designations can override the default, kind of things that happen with somebody's estate. If they don't have any planning in place, it can override what's in somebody's will. It can override a lot of different things. So they tend to kind of control when you have a payable on death or transfer on death, those control where things go. They tend to override quite a bit. So you just want to make sure when you're creating these plans that you also not only look at what you put in your documents themselves, in your will, in your trust, but make sure that your assets are also subject to that planning. So, if you don't have any planning in place, you're really relying on a lot of these defaults and just how the property is owned or how it's designated at death. Now, there's also default statutes of what happens when somebody passes away, if their assets would be subject to probate, for example. If you don't have any will in place and something is going through probate, well, the problem is the state of Wisconsin has really written out what will happen in certain circumstances with your property. Now, in a non-blended family, a more, first marriage, all joint kids, things are pretty straightforward. It goes to the surviving spouse, and then if both spouses pass away, it goes to their kids. But things get quite a bit more complicated in the intestate estate, not having a will, probate estate, when there are blended family situations. Some of the property will go automatically to the surviving spouse. Some of it will go to that person's kids. Maybe your intention was for it to all go to your kids. If it's a later in life marriage, maybe some of it, your intent was actually for it to provide for the surviving spouse for the rest of their life, but then ultimately go to the kids. So the defaults are there in sort of a worst case scenario to, sort of apply to what most people would want in those situations. But that really only seems to make sense in a traditional, like, first marriage, all joint kids situation, because everything goes to the surviving spouse, then everything goes to the kids in that context. With blended families, I would say it's probably less common for that default statute of some of it going to the spouse, some of it going to the kids, to be exactly the percentages that somebody might want. It might be half of it going to the surviving spouse, half of it going to their kids. It just really depends. And it gets even more complicated if that second marriage or subsequent marriage has some kids from a prior marriage and joint kids from that marriage. So you just have to be fully aware of what these potential outcomes are if you have no planning. And what I would always tell somebody is, rather than just assume that planning or that lack of planning and the default statutes actually matches your situation, always talk to an estate planning attorney who can help you determine, okay, well, here's what would happen if you did nothing, but here's what you want to happen, and here's how we'll help you get there. So, I would never say just go off of don't doing any planning. Always do intentional planning. That's always going to be the better option. So there are tools you can use to make sure that your ultimate end goal is what actually happens. Probably even when somebody has an estate plan, they have a will, they have a trust, one of the more common issues I see when people come in as a blended family is maybe the end result, the ultimate end result, ultimately depends not on their planning, but on who dies last. Because a lot of times their will still say, well, everything goes to my spouse, and both of their wills say the same thing. But then when you actually look at the separate wills, one person's will goes to their kids, the other person's ultimately goes to the other person's kids, the other spouse's kids. So if they happen to die second, they survive their spouse, their kids will get everything, right? Because in both situations, each spouse said everything should go to the surviving spouse first. But the problem with that is if you want to guarantee that your kids actually get what you wanted them to receive, you have to put other restrictions in place. If you just leave everything to that surviving spouse, they can change the beneficiaries, they can completely, revoke and, sign a new will. They can change the beneficiary designations on accounts. I mean, all of these things can be changed by the surviving spouse if you don't put any other planning in place. So you don't ever want your planning to rely on who dies first or second. You want it to be the same regardless of who dies first or second in terms of what your result is. You want your result to happen whether or not you're the first or second spouse to pass. So there is a lot of planning options that you can do to still potentially provide some restrictions on where assets can go. Now, in some cases, both spouses might agree that, okay, on the first of us to pass away, we have planning for each of us, that even on the first death, here's where some assets go. And they might say a certain percentage to the kids, certain specific assets to the kids, right? They might agree on that, and that's great. But it might also be their plan to say something like, well, I want to provide for that surviving spouse. I don't want everything to just go to my kids and then, now they're impoverished because maybe there was an imbalance in assets coming into the marriage. But I ultimately don't want that spouse to be able to change where that money goes or abuse that money or have remarriage of that surviving spouse impact where my money ultimately goes. So a lot of times, especially when somebody has trust-based planning, when they have a revocable trust or generally speaking, it's a revocable trust where this would happen. They might say, well, on the first of us to pass away, the assets that we have together in this trust will split into two separate trusts. One is the surviving spouse's property. They can continue to use it. They can change the beneficiaries on it. It's their assets they brought into the marriage potentially. But on the other side is what we would refer to as a family trust, where the trust itself has to continue to be used for the benefit of the surviving spouse during their lifetime. Any income in it might have to come out to them. It might be up to another trustee how to distribute any additional funds to that spouse over their lifetime. But it might also have restrictions in there then that surviving spouse may not change the beneficiaries, or they may only alter them amongst a collect group of people so that they have some ability to alter it, but not full unfettered access to it. And it might also have restrictions about if that spouse gets remarried, that surviving spouse gets remarried again, this either just goes to the kids right away, it goes out to them at the point of remarriage, or they has a requirement that they have to have a valid prenup that excludes that property in that family side of that trust from marital assets of that new marriage. And there's a lot of flexibility in how these are set up, but it provides that future planning down the road for restrictions on surviving spouses being able to change ultimate beneficiaries over the funds that go into it. Occasionally, first marriages will do this too. If there's concerns about like remarriage impacting the plan, if they both agree that, hey, we want everything to go to our kids, we don't want the remarriage of either of us to impact this, that's something that can be done. Now, there are some potential pitfalls with this, especially when it comes to like tax implications and potential like step up in basis for real estate, for example. So you'd want to be very careful about what types of assets are going into that family trust. But there are a lot of restrictions you can place in it. And in some contexts, you might say that surviving spouse is able to do quite a bit. They might be able to be in charge of that trust themselves if they trust each other enough to do that. But a lot of times it tends to be one of the kids from the other person's side of the family who passed first as well. So how much goes into that family trust can be wildly different depending on the situation. Some people might say it's a specific amount. Some people might say it's a specific asset or certain assets going into that trust. Other people might use a formula that basically helps them plan for estate taxes if that's what they're trying to do. So there's a lot of opportunities to do planning with that separate family side of that trust, especially if you want to restrict where things go in the end. The other option, and this is also pretty common too, is when somebody has a blended family like that, and maybe they don't have a trust already, and they're trying to avoid probate, but still make sure that things ultimately go where they want, they might actually have separate trusts where my property's in this one, yours is in there, and it still provides for that surviving spouse on the first death, but then there's no splitting of assets, just the assets in this one are for the surviving spouse until they pass away, and then it goes to my kids, right? So there's a lot of different planning opportunities you have with trust-based planning in particular. It is harder with wills to do this planning, mostly because then you're sending assets through probate on the first death, if that's where you're trying to place these restrictions. So it's much easier to do this through trust-based planning when you have blended families. In fact, blended families are often a reason that we look at doing trust-based planning to begin with, because the flexibility with trusts and not having to deal with a probate process as part of that first death can be really, really beneficial for the family overall. I do also want to talk about, though, with blended families, I mentioned the long-term care component, how this can still be an issue dividing assets out on the first death. So when it comes to this family trust, because the surviving spouse is the beneficiary of it during their lifetime, assuming they haven't remarried and triggered anything like that, it could still be subject to long-term care expenses. So you're not automatically protecting your assets from your surviving spouse's care by using this family trust planning. They are the beneficiary. It could be available for these things. So it could still be subject to nursing home expenses if that surviving spouse is in need of care. The other pitfall with this separation of assets on the first death is if that trust is never set up for the surviving spouse, and certain assets just go to the kids right away. If you in Wisconsin skip the surviving spouse, you leave things to other people and it's not all left to that surviving spouse, and that surviving spouse needs long-term care. The issue is if they're already in a facility, they're already receiving care, and maybe they're already on Medicaid, receiving payment for their care. If everything doesn't go to that surviving spouse or for their benefit, they could lose and will lose their Medicaid benefits at that point. It will be what they call a divestment by death. So you have to, if you're concerned about long-term care expenses, in addition to blended family planning, need to look at, well, how concerned are we about our ability to self-fund our care? If somebody came in with a blended family, wanted to skip some assets on the first death directly to the kids, and they had, billions of dollars, that's an outrageous number, but just as an example, I'm not going to be concerned about that person, causing an issue for themselves for long-term care. Where this is an issue is with your more traditional blended family, where someone comes in and they may not have the ability to self-fund care forever. Care is expensive, and long-term care in particular is expensive. And we're generally looking at assisted living costing anywhere between maybe $5,000 a month on the lower end, up to $8,000 or $9,000 a month for memory care per month. And that's very expensive, right? So people in retirement may not have these unlimited funds to cover this out of pocket. So if you skip some of those assets directly to the kids, and that surviving spouse would need them to help pay for care at some point, and in the 5 years after that skip occurs, or if within the 5 years after death they need Medicaid, they could have a Medicaid qualification issue because a divestment occurred. They should have received all of those funds. So you just want to be very careful when you're thinking, oh, it's just easy, we agree on this, things should go to our own kids on our first death, that's not going to cause a problem, to realize if you would also be concerned about long-term care planning within the 5 years after that spouse passed away, that you need to be aware that that could be a divestment issue too, and disqualify that person temporarily from Medicaid, from qualifying for Medicaid. And it's even worse if they're already on Medicaid because they're already qualified, and then they lose their benefits because of that skip occurring. So there are ways around that issue where you can still guarantee things go where you ultimately want them to your side of the family, to your kids. But you also need to potentially have things set up where they still initially do go to that surviving spouse, or for the care of that surviving spouse, in what's called a supplemental needs trust. Now in Wisconsin, for this to not count against the Medicaid divestment rules, this supplemental needs trust must be set up in somebody's will. So when we're doing this planning, we're often trying to prevent that skip, at least initially, from occurring, but ultimately controlling where things go. This supplemental needs trust, anything that the spouse inherits in this type of trust does not count against them for qualification purposes. So as an example, somebody could leave their $1 million IRA into this testamentary supplemental needs trust for the surviving spouse, and it would not disqualify that surviving spouse from care qualification if they inherited it, even that supplemental needs trust, through that will. So it can be really beneficial planning to, still not have things be available for care, but ultimately not kick that spouse off of Medicaid when they're in need of it the most. This supplemental needs trust is for the benefit to supplement the needs of that surviving spouse. So the kids are still going to have to wait to get those assets. Your kids from that prior marriage will still have to wait. But at the very least, that trust being set up for that spouse, when that surviving spouse passes away, it still goes where you initially directed it to. So you're still not hoping that, this all depends on which one of us passes first, where things ultimately go. You can prevent that surviving spouse from losing their Medicaid access, inheriting this testamentary supplemental needs trust, the assets that you would otherwise want to leave to your kids still. It could be used for the care of the surviving spouse to supplement care anyway, but it won't count against them for Medicaid. And you can still ultimately control where the remainder of those funds go. So there might be choices that you have to make as a married couple with a blended family, where you're trying to plan for, okay, there's pluses and minuses to these things. There's risks in skipping the surviving spouse directly and just going directly to the kids. But there's also the potential that if I leave things for this surviving spouse and this supplemental needs trust, that maybe the family decides to use it all on that person's care to supplement their care if need be. So you have to look at your situation and determine, which of these planning options are better for you. And, someone like me or another estate planning attorney ultimately can't decide what's most important for you. We can only tell you what the risks are or what the benefits are of certain planning options. So when you come in and meet with an estate planning attorney to talk about these issues, just have these ideas in mind of, well, okay, here are our primary concerns. And we're aware of some of the risks of either of these things, but, based off of that, which risk is more important, or which benefit is more important to you, which risk is most concerning to you, right? So there is some potential tax planning you can do, some better tax planning you can do as well when it comes to which assets, if you do decide, hey, we're leaving certain things to the spouse versus certain things to the kids, from a prior marriage on the first death, if those long-term care expenses aren't a concern of yours, and the care of that spouse is well covered by other assets, there are still some tax concerns that you might want to be aware of too. So there are better things to leave directly to your kids than to a surviving spouse. For example, IRAs or retirement accounts are a really big one, especially right now that we have with tax concerns. So your surviving spouse and your children, if they're adult children, are going to have wildly different tax situations upon inheriting a pre-tax IRA or 401k or 403b, any type of retirement account like that. The surviving spouse has the option to roll it over and turn it basically into their own IRA. And then, they use their own life expectancy to draw out the funds. They can, or they can wait until they would have to start taking out required minimum distributions, depending on the age at which you pass away. The kids, on the other hand, in most situations, there are some exceptions to this, but in most situations, adult children are going to have no more than 10 years to take out those funds. So if I'm even a 60-year-old spouse and I inherit an IRA, I have a much better, from my spouse, I have a much better tax situation, because not only do I not even have to start taking it yet, I can wait until I'm 75 at my age, by the time I would have to start taking it out. I also, at the time I have to start taking it out, can use my life expectancy to draw that down and spread out the taxes. So I will pay a much lower tax rate overall on that money than somebody else would if they had a shorter period of time. Now, adult children, if they don't have a disability or a chronic illness, so adult children, they have no more than 10 years to draw those funds down, regardless of when they inherit, as long as they are an adult. So you obviously are going to expedite the taxes if you have a shorter period of time than that surviving spouse. So one consideration when you're looking at how do I split assets on the first death, if again, long-term care isn't a concern, is, well, if you would want a certain amount of your assets to go directly to the kids on the first death, which assets make the most sense? And if you have other options outside of the pre-tax retirement accounts, that's better, right? Because the tax result is they don't have to take it out over 10 years. If it's like life insurance proceeds, they just get cash. If it's a cash account, they just get cash. If it's stocks, they get a step up in basis on your death and don't have to pay tax on the sale, at least if they sell it relatively quickly. If you have a Roth retirement account, if you had to choose between two retirement accounts to go to your kids, it'd still be better for that Roth to go to the kids for tax planning reasons than a traditional pre-tax retirement account. Now, I understand that in some situations, your ability to do planning around this might depend on what percentage of the estate is going directly to the kids, what value is going directly to the kids, and the breakdown of those assets within your estate. If you have everything in a pre-tax IRA, those options are a little more limited than if you had pre-tax IRA, life insurance proceeds, all these sorts of things. But that gives you some context of what these tax concerns might be, it also gives you the opportunity to potentially do some tax planning. Maybe if you haven't looked into it, look at Roth conversions to help get more into a post-tax account, work with your accountant, your financial planner on that. Maybe look at getting life insurance if you're looking for a tax-free transfer, income tax-free free transfer at death. If you know, life insurance is often something people overlook in that context because they're thinking of it more as I just need to replace my income if I pass away first, if I'm still working. But in the context of tax planning, if you are trying to give some income tax-free transfers to the kids, that might be a way to do it on the first death. Again, it's going to depend, and you would obviously want to work not just with an estate planning attorney on this, but also your tax professional, that your CPA that's advising you, your insurance agent that's advising you, your financial planner that's advising you. It's not a one-stop shop where you're going to every one person, they're telling you all of these answers. It would be a team effort to really make sure you're getting the most tax efficient planning done for you. So things like real estate, stocks, cash, those can be a relatively tax efficient way to transfer assets to children on the first death without them definitely having to pay income tax on it. Now, this is a totally different discussion from what would be part of someone's taxable estate for estate tax purposes. I won't go into a whole lot of detail on that just because that's an entirely different discussion outside of which assets you're using to fund that transfer. It's kind of in addition to that. Now, don't worry about estate taxes for the most part. If you have personally less than about 12.92 million is the exemption. So pretty much think of it as if you have less than $13 million in assets yourself, and between you and your spouse have less than $26 million in assets, you're probably not concerned about estate tax concerns at this time. Keep in mind that number will go back down to the pre-2017 levels adjusted for inflation at the beginning of 2026. So we're estimating it'll be around $6.5–7 million for that. So 6–7 million per person. So if you're somewhere in between those two numbers, maybe be concerned about estate tax planning in addition to blended family planning. One thing to really keep in mind when it comes to blended family planning is a lot of people will also look into or look and rely on marital property agreements as a way to protect assets or do estate planning and marital property planning from remarriage concerns. So marital property agreements, prenups are a marital property agreement, a type of marital property agreement. You can also do postnuptial agreements after marriage to decide how you want assets to be categorized. Marital property agreements can work great for estate planning. They can decide what is the individual versus marital property of the spouses so that you eliminate certain rights of that surviving spouse over certain assets to claim it as part of their assets on the death of that first spouse. They can work great for remarriage concerns, but they are not great tools when it comes to deciding what is or isn't available for somebody's care. So again, from that long-term care standpoint, just because your marital property agreement says this asset is mine and mine alone, doesn't mean you can just skip the spouse again and leave it directly to the kids. You still need to look into using that testamentary supplemental needs trust through your will if that is a concern, if the care of the surviving spouse would be a concern. Now, it is really important with those types of plans, with those testamentary supplemental needs trust plans, it is very important to have a marital property agreement that does separate out property as individual from married property, because you can more fully protect individual property in that supplemental needs trust as opposed to marital property. But that's in conjunction with that planning. It's not the marital property planning, marital property agreement that separates out individual property by itself is not going to be enough to fully protect those assets. So you do need to be aware that just because your marital property agreement says something, especially if you're married, you're both still living, a separate marital property agreement is not necessarily going to matter for Medicaid. It may matter at death, but it will not if both of you are still married and still living, because Medicaid doesn't categorize assets based off of a marital property agreement. They look at what types of assets are they. So like a bank account, regardless of whether it's in the healthy spouse's name or the spouse who's receiving care's name, no matter what the marital property agreement says, that is an available asset for care and for both spouses. What they will look at in terms of what's available and not and whose name it's in is really like retirement accounts. The healthy spouse's retirement account is not available for the spouse who's in care. It's not available for their care. So there are some exceptions to that, but don't rely on the marital property agreement while both of you are still living to suddenly say, yeah, this is not available for my spouse's care because we agreed 20 years ago that this is how things are split. That's not how Medicaid's going to necessarily look at it. So I'm at the end of my time here, and I don't see any questions right now. But if you do have any questions, you can always email learnmore@hooperlawoffice.com, that we kind of get questions that come in that way and see them come up. We do have next week, our topic is actually on common probate myths that people maybe have heard and run into issues when they're dealing with somebody's probate estate. That will be at our normal webinar time at noon next Wednesday. So if you want to sign up for that, you can always sign up for that as well and attend. And keep an eye out again for that email that has the feedback form with your option to have us reach out to you to set aside time for an initial consult. Again, those are complimentary. And then we'll also send out to you via that same email the document finder handout that we have for you today. So this is a really complicated topic, and I could talk probably for another half hour on this if I had the time. But it's a beautiful day outside, so I'll let you all go enjoy that. Thank you all for joining me, and I hope to see you guys next week when we're talking about